Thank you for joining us for 3Bs on the Law podcast, hosted by Trisha Barita, Camille Canali, and Susan Dawson. Disclaimer, this podcast is for entertainment and informational purposes only, not meant to provide legal advice, and does not create an attorney-client relationship. Also, remember, laws change or they differ by jurisdiction, so this is not a substitute for seeking legal counsel in your jurisdiction on the current law applicable to you.
Hi, everybody. Welcome back to season 5 of 3Bs on the Law. Can you believe we've made it this far?
Can't believe it. Season 5.
I know. We have a really exciting season planned. But for those of you who haven't joined us before, I'm Camille. I'm the California B, and I'm here with Susan.
Yep, I'm Susan, and I am the Illinois, Wisconsin B. We're missing one of our Bs tonight, but we missed her, but she'll be back. And yeah, I'm really excited about this season. I don't know what people know about how podcasts work and all of that, but obviously we've gotten together and we've planned and we've talked about what we want to do this season. And we have some really cool topics coming up. Many of them are tied into some hot topics in the news, right, Camille?
They are, including our first one tonight, which is about the National Labor Relations Board. Which, for those of you who don't know what the National Labor Relations Board is, or the NLRB as it's more commonly known, it is an independent federal agency that protects employees from unfair labor practices and protects the right of private sector employees to join together, or more commonly known to unionize. That is what the NLRB is primarily known for, is protecting the rights of workers to unionize. And so it's been in the news quite a bit because Starbucks has been in the news for unionizing, and Amazon. And so it's a hot topic. And even if you are a small employer, you should be aware of what employees' rights are with respect to talking about unions. Right, Susan?
Right. A lot of employers don't realize it has nothing to do with the size of your business. Unionizing is unionizing. And the reason that it's in the news now is Tesla, the new case that just came out where the NLRB actually overturned a recent ruling by the NLRB, which actually overturned our old ruling by the NLRB. But anyway, the recent ruling that overturned the rule on wearing insignia and union logos and labels and all of that on your clothing, and whether or not companies can prevent that. So tell us a little bit what happened, Camille.
So it's really a pretty simple case. Employees at Tesla wanted to wear a t-shirt with their union symbol, and Tesla said, no, our policy is that employees wear black shirts or they wear a Tesla shirt. And the NLRB came back and said, employees are allowed to wear union insignias at work. And so the real gist of this is that the NLRB found that the insignias for the union are used to advocate for workplace interests of the workers, and the law protects them. It's protected speech. That's the big takeaway of this case.
Right. I mean, they did acknowledge that there can be some special circumstances. You might have a safety issue and they can't wear buttons, or, there can be some special circumstances. So it's not an absolute bar. But in this case, Tesla tried to say, oh, well, we like to be careful and make sure that that nothing gets on the interior of the cars. And if we don't know who manufactured it, it could rub off on the seats or on the car. And so therefore, no, you can't do that. And the NLRB basically said, yeah, you have no proof that any of these shirts caused or could have caused any of that problem. You're not meeting the special circumstances criteria. And just like you said, Camille, this is, according to the NLRB, this is a huge way in which employees are able to promote unionizing promote and support their unions, advocate for workers' rights, and to prevent them from doing that is not allowed. So interesting case coming down and on the heels of so much interesting news and developments with the NLRB.
Right. And I think, what's really interesting is that NLRB uses this quote, special circumstances, close quote. And even the NLRB puts it in quotes, the special circumstances, which I always find interesting. And that's the test. And it's really a very factual test that is very difficult, I think, at least, to overcome. And so, if you are not going to allow employees to wear union insignia, you better make sure that you can beat that special circumstances test, or you could be in some hot water.
Right.
And
so, yeah.
That's really all I've got to say about that.
Yeah.
Anything else, Susan?
Yeah, no, just again, reiterating that keeping in mind that in this case, there was an actual union formed, but if this is employees that want to form a union or interested in joining a union, that would apply as well. And again, it doesn't matter what size your business is. You do not have to be Tesla or Amazon or Starbucks to be facing these issues. A small business, the employees can try to unionize or join an existing union there as well. So it's important everybody knows.
Great point. All right, everybody. Thank you so much for joining us on this first episode of season 5 of 3Bs on the Law. Thank you for joining us on today's podcast of 3Bs on the Law. Don't forget to like and subscribe to our podcast. We also welcome any comments. If you'd like to get in touch with us or suggest a future topic, you can email us at 3THREEBsonthelaw@gmail.com. And because we're lawyers, we need to remind you that this podcast is not meant to provide you with legal advice and does not create an attorney-client relationship. Thank you again for joining us, and have a great day.